just declaring fundamental rights was not sufficient. It was not enough. Our constitution makers had to create an enforcement mechanism. And that's what Article 32 provides. Article 32 creates a legal weapon which has been placed into the hands of citizens. So in the case of the violation of fundamental rights, they have the right to move the Supreme Court. And the right to move the Supreme Court, that is itself a fundamental right. And apart from Supreme Court, they can go to the High Court as well, under Article 226. So Supreme Court and High Courts are empowered to issue writs. What are writs? Well, writ is a special order. And as I have said, under Article 32, Supreme Court can issue writs, and under Article 226, High Courts can issue writs for the protection of your fundamental rights. Now, if you see the historical origin of this concept, so this entire concept of writs was inspired from the English law. In England, the king would issue prerogative writs. In England, they would be known as prerogative writs. It was a royal prerogative of the King of England to issue some special orders. They would call them prerogative writs to courts, to officials, in case there would be any injustice or mistakes on the part of courts or officials. So from there, this entire doctrine was included into Indian Constitution. So as I have said, Supreme Court can issue writs, High Courts can also do it. Is there any difference? Yes, there are differences. So Supreme Court can issue writs only in the case of fundamental rights. So if you are an aggrieved citizen, you believe the violation happened, you can bypass all the agencies and you can knock the door of the Supreme Court. And in the case of High Court, writs can be issued in the case of violation of both fundamental rights as well as ordinary rights. So in that aspect, the writ issuing power of High Court is wider than Supreme Court. Not only that, in the case of the Supreme Court, it's your fundamental right to move the Supreme Court. Right to get your fundamental rights protected itself is a fundamental right. So Supreme Court cannot reject or ignore such petition. But in the case of High Court, it is a discretionary power. High Court can ignore, High Court can reject. Okay. So there are 5 types of writs. I hope you would have heard about those writs. There is habeas corpus, which is issued in the case of illegal detention. And the court examines the validity of that detention or arrest, whether that arrest or detention happened on genuine grounds. And Supreme Court or High Court, for that matter, can issue such writs to both public authorities. These can be issued against public authorities as well as private individuals if there is a case of kidnapping or house arrest. Okay, so if the detention has happened and you are not aware about the location or whereabouts of that person, so the family member of that person can go to the Supreme Court, either Supreme Court or High Court. Then there is mandamus. Mandamus can be issued against public officials, corporations, departments, government departments, tribunals, if they are not discharging their duties. What they are supposed to do, the duties they are supposed to perform by law, if they are not doing that, in that situation, courts, Supreme Court or High Court for that matter, can remind them of their duties. So in that regard, mandamus is ensuring public accountability. Okay. You applied for a certificate, you did not get it on time. And that actually impacted the admission process. You had to take the admission in a college and you needed a certificate, but you did not get it. And your whole year got wasted. Are you understanding? So for that, mandamus is there. Then there is another writ which is prohibition. And it is issued by the higher court to a lower court, if the lower court exceeds its jurisdiction. So the higher court will ask that this case does not fall in your jurisdiction. You cannot hold the trial. You cannot hear this case. For example, let's say there is a consumer court and consumer court is hearing a criminal case. So in that case, higher court will issue a writ to that consumer court. That is writ of prohibition. So it can be issued to these inferior courts and tribunals as well. Then there is certiorari. In the case of certiorari, lower court has already acted delivered the verdict. And in that case, lower court exceeded its jurisdiction. It means that court was not supposed to hear that case. But that court heard that case, delivered the verdict. So the damage is done. That court has already acted. Verdict has been delivered already. But it was not supposed to do it. So what higher court will do, higher court will quash that order and transfer that case onto itself. That is the writ of certiorari. And as per the Supreme Court ruling in 1991, this writ of certiorari can be issued to administrative authorities as well. Let's say custom authorities imposed a penalty and delivered some kind of judgment wherein there is an imprisonment. So they cannot do it. So the higher court will issue the writs. It will issue the writ of certiorari. Then there is writ of quo warranto. It is issued in case if there is illegal occupation of public office. So you are not qualified enough to be holding that public office, you are still holding it. So any public-minded citizen, if you believe that the chairman of that particular government body does not deserve to be holding that office, so you can file this petition and the writ which will be issued, it is known as quo warranto. By what authority are you holding that office? You don't qualify, you are not eligible. Okay. So these writs are ensuring the rule of law, constitutionalism, and there is nothing which is above the constitution or law for that matter. Okay. So that's what you should know about.